And I've been excited about corporate form, partially because I'm a corporate lawyer. It's all I do. It's all I have done for 15 years. I've been at a big law firm. I've been moving money from one corporation to another corporation. I've been moving money from large investors. But it was a number of years ago where, for a lot of personal reasons, I started reading Paul Hawken, and I really became convinced about the business need for sustainability. It was about 2001, 2002. And it didn't jive with the corporate form. I was representing a lot of the typical types of corporations that are out there. And all of the corporations, except for nonprofits, they have a business judgment rule. And I'll talk, I won't talk briefly, I'll just summarize for you. There are a lot of corporate forms, but the primary, except for the nonprofit, the primary purpose of the corporation is preserving shareholder value. And in fact, legally, there are fiduciary duties. There's the duty of care, there's the duty of loyalty.
It's a very cool slide.
And they basically require, there you go.
Okay.
They require legally corporations to emphasize shareholder value. Those are tempered by the business judgment rule. And a lot of people ask me, why are some corporations emphasizing sustainability and able to more than others? Some of it is because, like with the B Corp, they have a contract with their shareholders and they set up a different type of form, like an LLC. And others, it's because they avail themselves of the business judgment rule. But there's still, in my view and a lot of other people's view, the business judgment rule doesn't go far enough. It doesn't give boards and management enough flexibility because, quite honestly, from a legal perspective, if you go too far outside of the box in emphasizing social or environmental factors to the detriment of shareholder value, you have legal risk, you have legal liability, and if you grow up and get big enough, shareholders can sue you. And one of the results of the financial disaster that we're in right now is that the plaintiffs' bar, in terms of groups of shareholders that get together and then hire really high-priced lawyers and sue big corporations, is about tenfold what it was 2 years ago. So our view, and a lot of people's view, is all of those lawyers are now looking at the big financial institutions they're going to go after and sue them. The next easy place for them to go in 2 years is greenness, is looking at whether or not companies are going too far. And so one of the things that a group of us, and you can go to the next slide, a group of us in California are putting together is really a totally different corporate form, is creating a new, and you can go ahead to the next one, a new safe harbor, in addition to the business judgment rule that will allow boards and management ultimate flexibility in choosing among various factors, including shareholder value, but also including social and environmental purpose that is agreed up front with shareholders. This group, there are 10 drafters. They include corporate partners from the top law firms. They include law professors from UCLA, Berkeley, and Stanford. They include the general counsel of some of the large socially responsible investors. And this group is working with folks like Jeff and Jay and getting a lot of feedback. And we're actually fairly far along. We have folks in the legislature who want to sponsor it, with the California Commissioner of Corporations who is sending his representatives to our meeting. We have a large advisory group, and I've actually gone out and tried to find the lawyers who represent all of the big money in the state, the corporate lawyers at all of the large law firms, and ask them to be on the advisory board so they get copies of our drafts. And my view is when you set up this corporation, hopefully a year or 2 years from now, and they go to Latham or Wilson Sonsini or Fenwick or Gibson, they're going to be partners in those law firms who don't think it's a crazy idea, that there is limited liability for boards and management to really emphasize the social and the environmental in addition to or to the exclusion of shareholder value. And just finally, some of these specific issues that we're dealing with include how we define the social and environmental purpose, how you make changes to the purpose. This goes to what both Jay and Jeff were talking about, how you ensure that purpose is not diminished or doesn't change substantially over time as your investors change, how you make decisions, how much flexibility to still preserve the insulation from liability, how much flexibility you do give to boards and management. Transparency and accountability is huge. We've actually already met with the SEC and the New York Stock Exchange and NASDAQ because we are going to have at least the framework for additional disclosure. If your board is authorizing spending additional money and or taking money away from shareholder value and spending on social and environmental, there has to be reporting. There has to be a metric for showing your shareholders, your investors, that you are not wasting those funds. And that's a huge area that we're actually working on right now. Incorporation and the dissenters' rights. In other words, we are spending, at this point about 20 hours a week drafting the provisions to figure out how method could convert, which is an easier example, but how Chevron could convert into this kind of entity and, again, afford all of the rights to their shareholders that they have now. So this is what we're working on. In terms of timeline, we are hopeful that something will be out that you all will see by February. We should have our draft finished by about September. And then we're going to work with Jay and Jeff and others to try to see if we can't create a model code that could be used in a lot of different